Today on Law Next, artificial intelligence in law, separating the hype from the reality. My guest today is Khalid Al-Kofahi, Vice President of Research and Development at Thomson Reuters and head of the company's Center for Artificial Intelligence and Cognitive Computing in Toronto. In July, Thomson Reuters unveiled the next generation of its legal research platform called Westlaw Edge, which makes use of advanced artificial intelligence. Dr. Al-Kofahi spearheaded the development of that AI. I had an opportunity to sit down and talk to him during the annual ILTA convention recently just outside of Washington, D.C. This is Bob Ambrogi, and you're listening to Law Next, the podcast that highlights the innovators and entrepreneurs who are driving what's next in law. We'll get to today's interview in just a moment, but first, let's hear from the sponsors who generously support Law Next. And now, on to this week's interview.
Today I'm on location at ILTACon, the annual conference of the International Legal Technology Association, where Khalid was a speaker earlier today. Khalid, welcome to Law Next.
Thank you for having me.
I'm really happy to be speaking to you and honored to be speaking to you.
Thank you, likewise.
First off, I just wanted to start by asking you to introduce what is the Center for Artificial Intelligence and Cognitive Computing? What do you do there?
Well, I think of us as an applied R&D. A cooperative applied R&D, and we have a very simple mission, which is to help our business, Thomson Reuters, identify innovative and differentiating opportunities to serve our customers better, focusing on AI and machine learning. So we look at ways to build applications that understand the customer, the use cases, the domain, etc., enabled by AI and machine learning to transform and simplify how they do their work, focusing on mostly machine assistant as opposed to replacing a person. Yeah.
I want to talk very specifically about some of the work you're doing, but I wondered. There is so much hype around artificial intelligence in law, and I wonder just sort of at a high level, what's the most common misunderstanding that you encounter about artificial intelligence?
Oh, wow. I think there is so much hype that there isn't one. I think there are multiple misunderstandings. I think probably the most familiar one is the idea of a robo-lawyer.
Yeah.
And
that robots are going to take over the practice of law. And
personally, I don't think that general AI exists today. I think building a machine that can that is self-conscious, that can do creative work, etc., in a general purpose sense. But at the same time, I think within the confinements of clearly defined vertical use cases, I think one can do a lot of good. Yeah. So the idea of a robo-lawyer doesn't exist. The idea that algorithms truly understand the nuances of the law don't exist. But at the same time, we don't need an algorithm to understand the nuances of the law as a lawyer does to be able to perform certain tasks, whether answer legal research questions, for example, or do deeper analysis of contracts, or do citation analysis of certain topics and highlight opportunities for practitioners and so on.
So is that where you see, I kind of flip around my last question, where do you see the greatest opportunities for AI in law?
I think in general, when I look at lawyers at a high level, what some of them or good percentage of them do, essentially they have often an information need, so they engage in a journey of research and discovery, and as they discover and find information, they start analyzing that information, and at some point they move into sort of making a decision, whether it's making a recommendation to a client, giving advice to a client, or writing an article or a brief or whatever. And in each of these stages, sort of finding the law, understanding the law, and making decision, there are significant opportunities for AI and machine learning to make these tasks simpler. I'll give you just a couple of examples. if you think about the finding part, the information need as it exists in practice is not necessarily suitable to be given to an application. So the information need could be a client walked to my office and sort of explains the injustices that were done to them. I can't take that narrative and give it to Westlaw. I have to analyze and synthesize that information, put forward, at least mentally, some hypotheses about the claims and the legal principles that I want to apply to these claims and so on, and then translate that into a set of queries or questions, and then engage with Westlaw. So the gap between the information need as it happens in its raw form and the touch point with applications in general is very, very wide. And one area for AI and machine learning is how to bridge that gap. Another area, and this is whether you are using Westlaw or Google or anything else, every transaction, every interaction with an application is often treated as an independent transaction. So you ask a question or a query, you get results. You ask the second question or a query, you get a different set of results. And these two are treated often as two independent transactions. Just like you and I having a discussion, and every utterance, every sentence, we start from scratch. We can't, systems don't allow you to elaborate and refine. You lose that continuity. And to me, that is how we learn, that is how we research, that is how we do things. And the applications need to mature to allow us to sort of have these kind of interactions. And so that's on the find and sort of research and discover and find. On the understanding, for the most part, other outside of sort of certain applications that analyzes contracts for users, for the most part, from a technology perspective, lawyers are left on their own to analyze and synthesize whether it's a document or an event or whatever it is. From a content perspective, we have analytical law that is designed to help people understand the law. We have practice guides, we have etc. But from a technology perspective, outside of contract, for the most part, people are sort of left to their own devices. And then when it comes to decision making, again, from a content perspective, you have checklists and practice guides and practical law and things like that. But from a technology perspective, there remains a lot of opportunity remains for us to capitalize on. So again, help people find, help people understand, help people make better decisions or decisions based on data and analytics as opposed to based on intuition.
So last month you introduced Westlaw Edge, which in some ways hits on all three of those points that you were just talking about. How is artificial intelligence part of Westlaw Edge? What is the artificial intelligence component of Westlaw Edge, and how is that working?
Very, very good question. So, as you know, in Westlaw Edge, we released 4 main new capabilities: legal question answering for legal research, overruling risk or the orange symbols, litigation analytics, and statute compare. For question answering, the underlying task of the question answering is a classical AI problem. The underlying task was, how can we build an application that has sort of a decent understanding of English, can synthesize language, can understand the syntactic and semantic structures of documents as well as questions.
Not just of English, but of English legalese.
English, and not just the law, English in general, because that's sort of the first layer.
Okay.
The second layer is extended to understand the nuances of the law. So a statute of limitations is a concept. It has a jurisdiction. Often in the context of there is a time element, there is a crime element to it. So build AI or natural language processing algorithms that understand these concepts. And we define sort of many concepts for the machine to understand them. And the third layer is teach it how to answer questions. Yeah. So often people, when I talk to people about, we are building a question answering capabilities for the legal domain, they only think that we are teaching it legal concept. And to the contrary, because I often say if it happens in life, it happens in litigation for the most part. Yeah. So we need to understand not just the law and the legal concept, but how this law and how these legal principles are applied to facts. And that's sort of the general English. Yeah. So once we develop these capabilities, sort of teach it English, we don't necessarily need, we train it on general English for that. We train it on sort of news, we train it on available general corpus, but then we train it on the law itself. Yeah. And then we give it what I call question answer pairs, where this is a question, this is the right answer, and we represent the problem in such a way that we would like the algorithms to make the connections between the questions and the answers on its own. Instead of us codifying and manually enter these connections. And this is how we guarantee that the algorithm sort of generalizes to different types of questions. So that's one area, question answering for legal research. The second area is overruling risk. And essentially the task there is, can we assign a probability that a decision, an authority is no longer good law, even though it has not been specifically overruled. Yeah. And the underlying problem there is...
There's not an express reference to it,
Yes.
express citation to
Yes,
it.
without it being expressly referenced. Yeah. And sort of we represent the problem there as follows. Does a decision not only cite an authority that has been overruled or abrogated, but does it also rely on it? Does it cite it for the same reason that it was overruled? And does it rely on it? Yeah. And as you can imagine, legal language sort of is not necessarily codified. So when a case cites another case, the language is continuous. Yeah, they discuss it sometimes at depth, sometimes they can discuss some of the legal concepts, sometimes they discuss how that case applied the law and its reasoning. That's one part. But then we have to decide, does it really rely on it? And that's a harder question. In fact, it turned out that only about 24% of decisions that cite a law that an authority that has been overruled for the same reason that that authority has been overruled, only 24% receive that orange symbol.
That's a startling number. I think
Yes.
I think a lot of lawyers would be really surprised to learn that.
We were surprised when we learned that, to be honest with you.
Yeah.
We thought it would be much higher. Yeah. When you cite an authority for the same reason it was overruled, 76% of the time, you don't rely on it.
Yeah.
And building an algorithm that can make sort of that distinction, does it rely on it, is sort of another example of AI. We use supervised machine learning for this task. Litigation analytics is a different beast. It's a purely sort of natural language processing task where we process docket entries, the motions and the counter motions, and sort of as people enter into join a lawsuit, and then the outcomes for these motions. And we link them all together. We put everything in a knowledge graph, and then we have that analytics layer on top of the knowledge graph. Anyone who read docket entries will recognize that docket entries can be convoluted. The language is often difficult and convoluted. And to be able to parse and understand that this is a motion, this is a claim by this party, and then 6 months later, that particular decision by the judge, by the court, refers to that particular motion, and then make these connections.
Yeah, I referenced earlier the sort of the hype around AI, and I think that a lot of the hype around AI makes it seem that AI is easy. And from hearing you talk a couple of times, I get the sense from you that you would perhaps take issue with that contention that AI is easy?
Absolutely.
What are the challenges of developing this kind of AI?
Absolutely. I think the first challenge is that complex AI applications don't come with a recipe. This is why I often say, these applications are not engineering problems or challenges. They are creativity required problems, where a solution must be invented. Yes, you may apply and use algorithms that exist or tools that exist, but to apply these tools on the problem, on the data, is not straightforward. So the solution need to be invented. The solutions are also iterative. I don't recall the last time that we designed an algorithm and we applied it and it worked. It doesn't happen often in practice. You apply it, hopefully it sort of works, and then we do thorough analysis. Why, did it make the mistakes that it did? Try to understand the underlying reasons. And often it's because the problem representation is not sufficient. I don't have sufficient features in the system, or I need more data. So you adjust and you repeat and you repeat and you repeat it until not only it works on the sort of the examples that you trained it on, but also works on unseen examples. It works on things that it did not see before. And we call it, the AI or the solution is able to generalize. And that iterative process is time consuming, it's difficult, and it requires a lot of resources.
And is there such a thing as good AI or bad AI? I mean, how does a consumer in the legal market or anywhere really, if you were in the shoes of a consumer, if you were at a law firm, how is one to evaluate a product, an AI product, when the science of it or the engineering of it is sort of so much beyond most of us to really be able to understand? What should they be asking? What kinds of questions should they be asking or looking at?
I don't think they should be evaluating the AI. I think they should be evaluating whether the application delivers sufficient value for them. Because if the application allows me to do my task, 30, 40, 50% faster, I honestly don't care whether it's an AI or whatever technology behind the scene, as long as it works. From a consumer perspective.
So the proof is in the pudding, essentially.
I would think so. I mean, in marketing, sell the whole, not the drill. Only engineers care about the drill. The consumers, care about the whole. And I think this applies here. As scientists and engineers, we care about the AI because we want to build, not because of the AI or the technology itself, but because we want to build applications or solutions that we can leverage, we can scale, we can build on top, etc., etc. But from a consumer perspective, it's really about, does it deliver the goods?
We'll get back to my interviews in just a moment. But first, let's take a break to hear from the sponsors who generously support Law Next. And now, let's continue this week's interview.
You've also talked about the importance of the data that you're using to develop, that you're basically applying the algorithm against to deliver whatever result it is you're working to deliver. So, how much does the quality of the data factor into the results you're going to get out of the?
I think that's a fantastic question. I think I tend to think of the quality of the data along multiple dimensions. One, comprehensive. Does it cover the domain that I care about? The second dimension is it accurate? Because the law evolves and some legal sort of rulings or principles that apply 10, 15, 5 years ago are no longer applicable. They no longer represent the law. And third, is it enhanced? And historically, publishers like Thomson Reuters, we have editors who will read the case law document, sort of identify the issues that are discussed in that case law document for each of these issues, write a head note, and then we classify that head note, the key number system, and so on, to help. And the objective is to help people understand and find the law. But it turned out that machines also need that help, require the same kind of help, because the law often involves people thinking by analogy, applying the same legal principle to seemingly very different factual situations. And without that help, without that additional classification, additional abstraction, it is really difficult for an algorithm to understand or to make sense of that analogy. So data matters a lot. It's the input and the output from the machine. It is what people come to us for in the first place. So they need to receive that data, but also the machines need to require high quality data in order for us to build the right algorithms.
So if I understood you, you were at this event in New York where Westlaw Edge was announced, and I heard you speak there. I was at this event. And when you talked about like West Search Plus, delivering the answers, that's the input for that largely is your editorial product, not sort of the raw case law or the raw legal data, if you want to call it that. Is that correct?
Is the input is all of case law, right analytical law, the key number system, the head note. The output is the
all
head
of that together.
Yeah, all of it is the input, but the output is the head note. In any question answering system, there are sort of two tasks. Yeah. One is understanding the question, and two is generating an answer. There are two kinds of generating an answer. Do I create an answer? Or do I find an answer? Yeah, finding an answer is much easier than creating an answer or computing an answer. Yeah, so 1 + 2, I don't. The answer is 3. I don't look for it. I compute it. And there are sort of natural language question answering tasks where the tasks require the solution designer to compute the answer. Yeah. For example, how often does Judge Johnson grant a motion for summary judgment in this kind of a case? You compute the answer. While for Westlaw Edge, sort of the enhanced search, the sort of the question answering capabilities for legal research is really about finding the answers. Yeah, and the answers in this instance is the set of head notes for now, at least.
Yeah, there's been a lot of writing lately about this sort of idea that different algorithms are inherent in both implicit and explicit in them are different biases based on what factors are included in the algorithms, who created the algorithms. What is your thought about how transparent a company needs to be about the biases that are inherent in their algorithms? And if, again, sort of from a consumer point of view, is that something that lawyers, given that lawyers have a duty to understand the technology they're working with to some extent, or trying to understand it, how transparent should a company be around that sort of stuff?
I think as you mentioned, I think there is data biases. There are data biases, algorithm biases, and designer biases. Yeah. So I think all companies should be very transparent about the data bias. Yeah, because that's sort of and that's easier to understand. As far as algorithm bias is concerned, sometimes it's harder. Transparency is required, but sometimes it's much harder to produce an explainable AI, than an AI that works, and we verify that it works through testing it on tens of thousands and literally high tens of thousands of questions or inputs in the case of Westlaw Edge. It's not because we don't want to be transparent. It's just because building an AI that can explain how it arrived at an answer is a much, much harder problem.
Yeah.
But it's something that we sort of aspire to, but it just doesn't exist. Yeah. And I think, designer bias is something that we test for internally. So, in fact, when we evaluate the features that we are building for Westlaw Edge, we don't just evaluate them by a single editor or a single attorney. Every evaluation is done twice by two independent people, and we compare, we measure inter-rater agreement, and whenever there is a significant agreement, we introduce an arbitrator who can talk with the two, etc. So we do a lot of testing to help us protect against designer bias and data bias internally.
Yeah, and when we use the word bias, there's not necessarily a negative implication with that.
Yes.
It's just to mean
absolutely
there is a
we all have
bias.
blind spots.
Right.
We all have blind spots,
Yeah.
and these blind spots can manifest themselves as biases in the overall solutions.
Yeah. So where do you see kind of the next big opportunities for AI to enhance legal research or enhance legal practice? I'm sure you probably can't tell me specifics of what you're working on, but on a sort of a conceptual level, where are you looking in terms of going forward with the research and development that you're doing?
Again, not from a product perspective, because a product is very different than an algorithm or a capability. Yeah. But I think when we look at some of the pain points as well as the opportunities that exist in the legal space, I think there are still significant opportunities in legal research. Going back to this idea of building applications that maintain context, that allow me to elaborate and refine my information need. And as I continue with that engagement, it generates algorithmic summaries for the things that I have seen, the things that I have interacted with, sort of the document that I looked at, the concept, and visually represent that for me. So that's, I think, maybe a longer term opportunity that exists in this space. I think, and this is again not necessarily an application, and it is definitely my own opinion, not necessarily something that is informed by internal company discussions. I think there is a need for all of us to find ways to simplify the law a little bit more than what it is today. 2-3 years ago, I believe the ABA did a study where they concluded that 80% of legal demand for legal services in civil law in the U.S. go unmet.
Right.
That's an access to justice problem.
Right.
Yeah. And I think technology can help reduce that barrier a little bit. Yeah. And maybe it's not good business. I don't know, but I think that's an opportunity that as a scientist who works in the legal industry, I would like to think about and do something about.
Well, you have ESP, because that was actually going to be my very next question, which is to ask whether you saw applications for AI to help address the justice gap, because it is it's not just in this country, it's a global problem.
It is, yeah. Certainly make it simpler and make it so a task doesn't take 2-3 hours from an attorney, make it take 10-20 minutes. Sort of that will reduce the overall cost. So simplification and introducing efficiencies will reduce the overall sort of cost structure. I think opportunities around alternative venues for dispute resolutions, whether it's online dispute resolutions or other venues for dispute resolution, is an area for us to, as scientists, as people who work in the legal industry, as lawyers, to think about. I'm sure there are other areas that that we can think about as well, but I can't think of.
You're a scientist more. You're not a lawyer, but do you have any concerns, or do you see that there are any ethical issues around the use of AI in law that legal professionals have to be thinking about or aware of?
I think in any when we use AI in any decision support system, for example, whether to grant a parole for someone or deny a parole, I think we need to understand how the AI works. Because if you can't cross-examine it, how can you trust it?
Right.
In sort of these decision support system applications. When it comes to legal research, we are even with features like a question answering, we are not presenting them as we are answering legal questions. We are presenting them as we are answering legal research questions. The burden is still on the attorney, on the expert, to make sure that this is the law, this satisfies what he or she is looking for, as opposed to rely on the technology. But once you start relying on the technology, then you need to be able to, quote unquote, to cross-examine it, understand how decisions are made.
Well, Khalid, I really appreciate your taking the time to talk with me, and it's been really interesting to talk to you, and keep up the good work.
Thank you so much. Thank you.
I've been speaking today with Khalid Al-Kofahi, Vice President of Research and Development at Thomson Reuters. A huge thanks to him for taking time out of his busy conference schedule at ILTA to sit down and talk to me about AI and law. And that does it for today's show. If you like what you heard, head on over to Apple Podcasts and leave a positive comment. And be sure to subscribe to receive future episodes. This is Bob Ambrogi. Thanks for listening.